Welcome to Between Two FARS. I'm Warneke Miller, and I am here talking with some of my favorite procurement attorneys, Robert Tepfer and Michael Mark, who are both icons in this industry and have been practicing procurement law for collectively, we're going, close to between 80 and 90 years between the two of you, right?
Yeah.
So we've got a whole lot of knowledge on the video today. And what we'd like to talk to you about is ASBCA litigation. We've spent several episodes talking about resolving disputes at the lowest possible level and what happens when you actually have to issue a contracting officer's final decision. So now we're going to begin a series where we are going to get you ready. Bam! You have just been notified that your contracting officer's final decision has been appealed to the ASBCA. Bob, Michael, what's the first thing we do?
Oh, I'm a big believer in that you hopefully had some kind of a meeting where you had all the key players weigh in on their opinions with regard to the final decision, because you want a consistent story and you don't want to find out with regard to what happened, later on in the case. You look disingenuous to the extent that the final decision, is deviated from and that the story changes. When you move into the possibility of seeing a complaint come up, you want to really intensify that. And as we have talked about on other occasions, you have an organizational meeting to find out who the players are, what they did. You have to find out their status too, particularly in this agency, because a whole lot of them may be contractor employees, which creates a variety of issues with regard to attorney-client privilege, third-party subpoenas, and that kind of thing. You need to make certain that you know what you've got. The program is willing to spend the money, take the time, dedicate the people, and dedicate the right people to putting together a proper defense. That's my perspective off the top.
All right, so when you're putting together the notice for this meeting, who exactly are you inviting?
Well, hopefully you've already talked to some folks at the creation of the final decision and kind of socialized that and made certain that, like, inspectors, field engineers, the contract specialists, the contract officer at the time, find out who the names of the people are, and you have them sit down and you go over the facts of the case again, and you make certain that everybody's on the same page. They won't be, but at least you can straighten that out and speak to it there, as opposed to later on down the line waking up with a set of depositions where you have folks taking issue with your responses, or worse yet, testifying with regard to it. You want to know what your case is really about, and you need to make certain that everybody is there. I've had instances, I can think of one case where there was like 50 to 60 people involved. And I said, this is great. I need to know what everybody did. And I said, but I only want, for right now, I want only the government employees. Whereupon everybody got up and only 6 people were left. That will tell you a lot about your case and reveal all sorts of complexities in your case. You need to know that.
Yeah, that's gonna, when you have a large contractor team, not only do you have the issue, can you get them to actually cooperate, but very often the contractor, if they're even willing to let them cooperate, they're going to want money for that. And who's paying for that? I think one of the things Bob said is getting the support. It's really important. Who's going to be, this is treated like a project. Who's going to be paying for this? Are you going to dedicate the bodies? And also within your office, the legal office, you now have a new primary responsibility, and that's to deal with this case. So you've got other things on your plate. How is that going to be handled? Can you get it offloaded? Who in the office is going to backstop you? I like to work, a first chair, second chair attorney, if at all possible, and it helps to divide the work, and it also gets you another set of eyes on the thing, in addition to being good training for the second attorney. So you need to, internally within your office, you need to say, okay, boss, here's my job now, and I'm going to need some support. And in addition, in order to conduct this litigation and all of the steps that we're going to be talking about, There's going to be funding involved, people that are going to be necessary. We may even need to bring a contractor in for administrative help. And these are all things that we can begin to discuss and raise with the client because they're going to have to fund this. I think Bob has pointed out in the past, if they want to give you the back of their hand, they're really not hurting you, they're hurting themselves. And that point needs to be made is, look, if you think this is a case worth fighting, then you need to resource it. Otherwise, we're not going to win this thing.
One of the issues that I've always run up against invariably is I'd be dealing with a particular office and I tell them what I need. And I think I've mentioned before that they view it as a legal problem. If you're lucky enough to get them to give you some of the people part of the time, they normally have to have one individual or a couple who kind of manage the documents, manage the scheduling, manage getting the funding, because it's not legal that's going to pay for travel and a litigation support contractor and that kind of thing. And invariably, they give you their beast team. And they think that they're really smart in doing that. And you have to sit down and explain that if they've given you people that are not necessarily dependable, are not necessarily familiar with that type of work, that their case suffers, not yours. And, right. You have to have that discussion early on because if you don't, it can get really ugly fast.
Yeah, it's important to let the clients know that a loss is not paid for out of the legal budget, is it?
No. In fact, I bring that up routinely and say, you know what, if you don't want to pursue this, we're quite willing to let you write a check.
Yep.
That is correct. Well, it sounds like some important considerations for this initial meeting as you get your mind wrapped around where to proceed and what the next steps are for this ASBCA litigation. Why don't we come back next time and talk a little bit about the complaint that was filed and how you dissect that complaint and what sort of things you need to look at. Sound good?
Sounds great.
Excellent. We'll see you again next time between two FARS.